Namaste. In the previous session, wherein Tarishi Agarwal ma'am has discussed about the object, the preamble, and some of the definition that are laid under the Mediation Act 2023. So in this session, we will discuss on the chapter 3 of the Mediation Act 2023, specifically a mediation agreement, that is section 4 of the Mediation Act. So when we talk about mediation agreement, before we move on to discuss about that, I would like to bring to your kindness that. So earlier we used to call mediation agreement as it is the terms and conditions of settlement. We call it as mediation agreement. But as per section 4 of the Mediation Act 2023, it is not. Because there is a slight difference between the mediation agreement and the mediation settlement agreement. So mediation agreement is an agreement wherein the parties agree to refer the dispute to the mediation. That we call it as a mediation agreement, and that which is laid down under section 4 of the Mediation Act 2023. Whereas a settlement agreement is nothing but wherein those are the terms and conditions on which the parties have settled the dispute, and that we call it as a mediation settlement agreement. So with this, we move on to the discussion of section 4 of Mediation Act 2023. So Mediation Act 2023 through section 4 empowers the parties to enter into an agreement that we call it a mediation agreement, wherein both the parties agree on to refer the matter or agrees to settle the matter through mediation. So such agreement should be in a written format, and it involves the parties and anyone claiming through them to submit all or certain disputes to mediation. That is, both the parties or anyone claiming through them can submit all or certain disputes to the mediation. This ensures the clarity and enforceability of the agreement. That is, both party agrees on to refer the matter to the mediation agreement, and such agrees or agreement should be in writing. Further, the mediation agreement can either be in the form of a clause within a larger contract or a separate standalone agreement specifically in relation to mediation agreement. This flexibility allows the parties to integrate mediation clause into existing contract or draft a specific mediation agreement. And this agreement, which is in a written form, it should be signed by both the parties involved, or it can be in the form of exchange of communications or letters agreeing to refer the disputes to the mediation agreement. And it may also be in the form of electronic form, that is by means of emails. It also works, but it should be recognized as per the Information Technology Act of 2000. It also includes that, or it may be in the form of pleadings in any suit wherein the other party has not denied that. So even that is considered as an agreement to refer the matter to mediation. Along with that, so this provision acknowledges various forms of documentation, that is the document that is signed by the parties agreeing to refer the matter for a mediation, or letters or any communication made through the electronic form recognized under the IT Act. Even that we consider as an mediation agreement for the reference of dispute to the mediation, or any pleadings that is not been denied by the other party, even that we can consider as a mediation agreement and for the reference of disputes to the mediation. So mediation clause reference. This refers to a reference to a mediation clause within any agreement constitute a mediation agreement if the agreement is in writing and the reference is such that it makes a clause party to the agreement. This ensures the mediation clause within the broader agreement and are recognized as well as enforceable. It also provides a lot of flexibility to the parties. That is, the parties can agree to submit any dispute to the mediation, whether the agreement to mediate was made before or after the dispute arises. This allows the flexibility and encourages the parties to use mediation at any stage of disputes. Section 4 of the Mediation Act also promotes international mediation. That in the context of the international mediation, the agreement must refer to the commercial disputes. The commercial dispute that is as defined under the Commercial Courts Act. This provision ensures that the international mediation agreement are specifically agreed towards the commercial disputes. So understanding these provisions helps the parties and the legal professionals draft a effective mediation agreement, ensuring that all necessary elements are included for the agreement to be recognized and enforceable. These provisions promote the use of mediation as a preferred method for resolution of dispute by providing a clear guidance for the formation and recognition of a mediation agreement. Thank you.